welcome back to another episode of In the Gallery with Laura Ali. I am your host, Laura Ali, and today we're just going to cover one cross-examination of a witness in the Adelson case that I just found to be just quite entertaining. I've watched this one a couple of times, so I just wanted to watch it with you guys and give my commentary. We're going to pause play as we normally do and get right into it. Move myself over here. And just a little backstory. This is the legal expert that Georgia Cappleman cross-examines. This is Donna Adelson's witness, and she basically, we're going to get into it, but she basically makes it seem like the Adelson, the Markel divorce, Adelson-Markel between Wendy and Dan, the divorce was not contentious. And it's like, it definitely was. But it's just so, and it's just so, the reason why I think I enjoy watching this is like, it fascinates me seeing people lying through their teeth or just like lying with the straight face and having no type of like flinch with it. And she's just sitting up there lying, and she's just like, I don't know if I can call it lying. She's being 100% disingenuous, and to say divorce is not okay. Let's just get into it.
Everyone can be seated. Please continue with your examination.
Thank you, Your Honor. Ms. Bailey, how did the Adelson-Markel divorce compare across the variety of cases?
This is still the defense. I guess this clip just has a little bit of defense, but I think it's important to hear how she responds to the defense questions.
Simply, it was routine, it was amicable. I've done similar cases that have had anything from 2-day to 7-day trials. I've had them range from $200,000 to $500,000 in fees and costs. I've had multiple financial experts, child development experts, vocational experts, all retained, deposed, testifying. I've had cases with multiple discovery issues, discovery over psychological records, financial records, third-party subpoenas, 2 full days of deposition of just one party. This was an easy case compared to many.
Did it look worse than it was because of the way in which Mr. Markel's pleadings were drafted?
Yeah, I mean, he drafted pleadings, motions, I think, and responses would be more appropriate than pleadings, but that's kind of technical. He drafted them like he was drafting a law review article or something. They weren't technically correct. They were verbose, they were hyperbolic. He used a lot of inflammatory language, but when you really looked closely at his requests of the court, there was no foundation for his.
How do you know that though? Like, that's for the judge to decide, ma'am. She's not the judge. She's acting like there was no basis behind his pleadings. But Dan felt like there was. And I've seen this before, so I know that's where George is going to go with it. But it's just like, it's just so bizarre that she can really sit up here and say that they weren't going to go through. You don't know.
Nothing further, Your Honor.
Cross-exam.
Get her, Georgia. Get her.
What is it you were asked to do in this case?
I was asked to review the documents I was given and to opine about whether this was truly a highly contentious custody case, essentially.
And why would your opinion about whether it was a highly contentious custody case matter?
Well, that's for somebody else to decide. I mean, I've done 2,000 cases, or give or take 100 on each side, and I think I have a pretty good judge of where this falls as far as contentiousness.
Sure, but you're somebody that has vast experience with a ton of...
Ma'am, someone was murdered. I think it's contentious enough, right? Like, someone was murdered. You cannot tell me that's not, that is, someone was murdered. I'm sorry, Georgia. I didn't mean to cut off Georgia, but it's just, it is very absurd.
Right?
Sure.
The parties only have experience with one divorce, right?
I don't know how many they have experience with,
So
but
isn't
sure.
the contentiousness in the eye of the beholder, in the sense that
I love this.
to you it might not seem like a big deal, but to the parties it might be the most important thing in the whole wide world. Do you
Well, that's
agree
one
with
reason-
that? Do you agree with that?
Ms. Cappleman, Ms. Bailey, wait for the question, wait for the answer.
Georgia's like, let me breathe before I go in on her. Okay, breathe, Georgia. It's okay, girl. I'm here with you.
Do not speak over each other.
Do you agree that a case, as a lawyer, might be routine, whereas to the parties it's the most important thing in the world?
To some degree. That's one reason I called Kristen, is Miss Adamson, in particular, of the lawyers in our community of the family law bar, is extremely measured and calm. And I find that when I litigate against her, we reach resolutions, that people stay measured and calm, and we get things done. She's not one of the other lawyers in town who may stir cases up or play on those emotions. So our job as lawyers is to explain to our clients when we get emotion. If I get something, for example, that, although I've never had, something similar to what Mr. Markel would file, the immediate response is to call your client and go, I know you're going to read this at first glance, so it's going to seem messy. But there's no legal basis for this, so don't worry. And my understanding is that is what she communicated to Wendy.
And when you communicate these things to your clients, hey, this is no big deal, this is no problem, this is a bunch of gibberish, do they always accept that?
Well, that's not the way I would present it, but
Do they ever get upset about the gibberish in the pleadings, the offensive materials in the pleadings, regardless of whether or not it's going to impact their chance of success in court? It can be emotional.
1,000%. 1,000%. I know people that just get upset about someone saying something about them just in passing. Like, oh, they said that about me. I can't believe they would say that about me. Or didn't like their post on social media. Like something so minor, right? And really taking it personal. If someone puts something in writing, specifically saying that I don't want my kids around Donna Adelson without supervision because she cannot be trusted with my children, I do think someone could get upset about that. Even if there was no quote unquote basis to it.
Be charged, can it?
I would say annoying more than emotionally charged.
You would not say that divorce and child custody issues are emotionally charged?
They can be, but in this case, they weren't.
They weren't? How do you know?
From the pleadings, because I don't have 10,000
But you're
pages in
not-
front of me.
You're not in the mind of the people whose lives are impacted by these pleadings. It's not just about pieces of paper and a binder, is it?
Correct.
I don't think that's what I said.
People's lives are impacted by the decisions that go on in court, which for you are routine. Would you agree?
In this instance, they reached agreement on all issues, so they had complete control of what was.
They reached agreement in all issues. Did they? I don't know if they did. Just because the divorce was finalized, it wasn't over. The pleadings were still going back and forth, clearly, because we know Dan filed the grandmother motion. We know that.
Out of the court.
Ma'am, could you please answer my question? Are people's lives impacted in drastic ways by routine matters that we see in court as lawyers?
People's lives change after divorce, certainly.
So, like, I may think I've got a bag of stinky garbage, but the garbage man might not think it's stinky at all. Do you get the reference?
I don't.
I'm sorry, when she said she didn't get that reference, I love that analogy. The stinky garbage analogy. You are the garbage man. You're around the garbage all the time. To you, the garbage isn't going to be stinky because you smell stinky garbage all the time. To me, or just a random person, that garbage is going to be stinky because they're not around stinky garbage. You're around all these pleadings all the time, so it's like, oh, no big deal. But to Dan and to Wendy, this is their only divorce. You've been through thousands. This is their only.
What is no big deal to us is a big deal to these litigants, right? You can't agree with that.
Perhaps.
You can't agree with it. Strike the question. You were asked, let me ask you this.
Georgia just snaps. She's just like, you can't agree with it. You can't agree with it. And that's it. Like, and I don't blame Georgia. Like, she is just like disgusted with this lady.
Something else. Have you ever had people get murdered or commit suicide based on the issues that are going on in your family law litigation?
I've never had anyone murdered. I had in one instance a Middle Eastern person committed suicide just because there was a divorce, and that was shameful. So nothing was it was literally the day after the petition was filed, and he had threatened, if you file, I'm going to kill myself, and indeed he did.
And to you, divorce is not shameful, is it?
To me, divorce is not shameful.
Divorce is not a basis to commit suicide, is it?
Not according to me, but I didn't grow up in Iran or wherever this custom or feeling.
Exactly, Ms. Bailey. To
derived.
that person, it was a reason to commit suicide, right?
Apparently so.
Aren't these issues raised in these pleadings potential fuel to make people upset?
Potential fuel to possibly make people upset?
Yes, ma'am. For example, you were asked about what we've called the grandma motion. You say, oh, it's no big deal, it wouldn't be granted, it was buried in there. But the allegation is, grandma is disparaging me to these kids, and I won't tolerate it, right? Couldn't that be upsetting to grandma?
You'd have to ask grandma. I don't know.
Exactly.
It shouldn't have been. There was no proof,
It shouldn't have been, in your opinion.
in my opinion.
Correct.
But in your opinion, divorce is no reason to commit suicide, right?
Correct.
Sure.
Your opinion doesn't matter.
Gibbers, according to the evidence in this case, means Jew in boots. It's not a flattering term by that definition or by your definition of someone that speaks gibberish. Can we agree it's not a flattering term?
No, it's probably not flattering, but I've seen far, far worse.
Shut up.
You've seen worse.
I have.
If Mr. Markel wasn't paying by the deadline, isn't that something that would be potentially upsetting to the parties or their family members?
I don't know how upsetting $80,000 would be. I don't know.
$80,000 is a lot of money, isn't it, Ms. Bailey?
Depends
Yes.
on who you are.
Exactly. So we'd have to ask the parties, right? Right?
Sure.
$80,000 is a lot of money.
I think on that issue, he clearly had the asset, so at the end of the day, he was going to pay. It was just a matter of jumping through hoops to get the money.
He was either going to pay, or he was going to get sanctioned by the court, or he was going to end up in jail, right?
I don't see any possibility he was going to end up in jail.
Okay,
But
well, you sat in the courtroom during Ms. Adamson's testimony,
I did.
didn't you? And
I
Ms.
did.
Adamson said that that was one alternative, an extreme alternative, obviously, but that's what contempt means, right,
But that
ultimately.
wouldn't even come into play until the motion for enforcement, and then he didn't abide by that, and then the judge asked him to do something else, and then he didn't abide by that. I think jail was pretty far-fetched.
Well, as long as he pays. ultimately the teeth is you go to jail.
No, that's not true.
It's not true. Okay. Ms.
yeah.
Adamson was incorrect on that point, I guess.
Objection, Your Honor, it's not a question that we just strike.
I'll rephrase it.
Was the objection again?
It's an improper comment on the witness's testimony.
Stay and please rephrase your question.
I said Ms. Adamson was incorrect on that point when she said jail was a potential option. Is that correct?
Well, I could break it down. There's two different matters in that financial motion on October 31st. One was the $70,000 still due to Wendy. Jail is not a possibility on that. But you don't send people to jail for failure to pay money. We don't do that. The $10,000 in fees to Kristen was more debatable because that could have been in the specter of support, and if you don't pay alimony or child support after repeated chances, I guess you could say, jail might be an option, but there's always a purge to that. So I've seen many times in child support, if you don't pay child support, then the judge says, bailiff, get, Mr. So-and-so or whatever, and then all of a sudden he comes up with money out of his pocket and he pays and he never goes to jail. So you always have the key to the jail when you owe a support obligation.
You don't know that though. Like, you don't know what would have happened. Like, she's trying to act like she has a all-seeing ball, a future-telling ball, and she can tell you what was going to happen on that day. You don't know what would have happened. They had to go to court to talk to the judge, and then we would have known what happened.
Technically, if he wanted to go to jail rather than pay Kristen the $10,000, eventually there may have been a hearing where that happened. I've seen one person in my career go to jail over child support.
Right, because they pay because they don't want to go to jail. If there was no jail and no consequences, they would never pay.
Correct.
Right?
Some people wouldn't.
Right.
And that's just support. There's no jail consequence to the $70,000 you win.
This is when you could see Donna looking at Georgia in a sort of an endearing way. Like, I think she respects Georgia. She may not like Georgia, but I think she wishes that Georgia was her attorney.
It was only the $10,000 to Kristen that could have possibly remotely been a possibility.
Did you see evidence in this case of Wendy taking her mother's suggestions, cutting and pasting them into an email as her own, and then forwarding those questions to Ms. Adamson?
No, I didn't see any.
And did you see, in your review of the evidence in this case, Ms. Adamson responding to those questions and Wendy then forwarding those answers to her mother?
I don't recall that. I don't recall seeing that.
Did you review the communications from Donna Adelson, both in the form of email and text messages, that suggest that she was in fact extremely disappointed and upset about the outcome of the relocation motion?
I did. In probably the 5 days after the relocation, which was, say, 4 weeks before the ultimate settlement in July, there were a flurry of emails where she was obviously upset.
Did you review Mrs. Adelson's communications after July 31st that suggest she's consistently still upset about this?
I wasn't provided.
So you were, I'm sorry, finish your answer. You weren't provided any?
I wasn't provided after the flurry, right after the relocation, before the final judgment was entered in July of 2013. After July 2013, I don't recall seeing any emails from Miss Donna Adelson about the relocation.
Did you see any emails from her at all post-settlement?
Not until maybe December. It was a while. October maybe.
Okay.
Several months.
If Dan Markel had agreed to the relocation post-denial, post-stipulation, post, it could still happen, right? I mean, if he agrees, it could happen.
Sure, if he agreed, she could have relocated.
All right. And if he was murdered, it could happen, right?
Well, obviously.
She shouldn't have said that. Like, I understand that she is the defense witness, but her saying obviously, it's like, yeah, obviously.
So you categorized Dan Markel's pleadings in a lot of different ways: baseless, untrue, unenforceable, gibberish, nonsense, suggestion of unethical filings on the part of his lawyer to sign off on them. Are you saying, I think what you're saying is that those things wouldn't amount to much in court because it's not really effective filings. Is that what you're saying?
What I'm saying is his motions post July 31st were not based in the law, and I don't think that allegations about accounts he knew of not being on an early filed financial affidavit would amount to fraud, and it certainly wouldn't excuse him not paying what he was supposed to pay under the terms of the court order. And the motions related, the motion in March 26th related to parenting, he was trying to enforce things that weren't in the marital settlement agreement. There was no court order to make her do the things he wanted her to do. So there's no basis for the court to have granted his motion.
Right, so they weren't going to be successful. It's your opinion they weren't going to be successful.
Yes,
Your opinion.
But would you agree that the things he was putting in there are inflammatory?
I would agree that they were inflammatory.
And they potentially could make the parties or their relatives upset to read those pleadings and those inflammatory accusations.
Sure, nobody wants to read those allegations, true or not, about themselves in a public record.
You were shown a bunch of binders on a case. That case has nothing to do with this case, right?
No, it was a relocation case.
All right. And that case, was anybody murdered in that case?
No.
Okay, so if somebody had been murdered in that case, there might have been a lot less paper, right? Case
Well-
would have been shorter if somebody got murdered, wouldn't it, Miss Bailey?
Yeah.
If there wasn't a party, the case would have ended, if that's...
And if our case, we hadn't had a murder, we might have a lot more paper in our case, wouldn't we?
No, because the divorce was over in July.
Divorce was over in July, but they kept filing papers, didn't they?
Exactly.
Well, and the case was set for hearing May 15th, 2014. So the motion that Ms. Adamson filed in October, and the motion that Mr. Markel filed in February, and then the motion he filed in March, were all set for hearing May 15th. And then Mr. Markel amped it up again, and on May 5th he filed the motion that accused Kristen of fraud, so she had to withdraw, so they had to move that motion. So had that not been filed, they would have had a resolution on May 15th.
We don't know that. How do
Correct.
you know it was going to go on May 15th? Could have gotten continued for any zillion different reasons.
Correct.
It was set for May 15th, and it was noticed for May 15th.
Set for May 15th, but at the time of Dan Markel's murder, litigation was still ongoing in this case.
It
Yes? Yes. And even after that was resolved, there would be nothing stopping them from having a bunch of other time-sharing issues or whatever come up, and they might have ended up with reams of paper, right?
Objection, Your Honor, calls for speculation.
Overruled, the witness has provided an opinion.
Correct.
Cross-examine.
I guess my
It's-
response to that would be, I think it would have been to Wendy's benefit to proceed with those hearings, because nothing makes someone stop filing nonsense pleadings and motions better than having them ordered to pay the other side's attorney's fees. So had they gone to the hearing on May 15th, and had Wendy have been successful, he would have very likely had to pay Wendy's attorney's fees. And I really encourage my clients in these situations to take it to hearing, so once the other side gets kind of slapped down, if you will, by the court and made to pay your fees, then they tend to back off.
But you don't know
That
that.
hadn't happened yet.
It had not happened yet.
And we'll never know when that was gonna happen, because we never got to that point. right?
Correct.
Clearly,
Because he was murdered.
clearly.
May I have a moment to confer, Judge?
Yep.
Thank you, Georgia. Thank you, Georgia. Thank you, Georgia, for it's like the attorney, she's trying to sit up there saying, like, she's speculating on all of these items that she has no proof that would have happened. You don't know that this would have been the end of it. It could have just kept on going. It could have been more and more pleadings. And truthfully, I think there would have been more and more pleadings. Because it seems like they just wanted to keep going after each other. That's just what it was. Yeah. So honestly, I do think that attorney was actually, I know it was Donna's witness, but I really think it really helped the prosecution a lot, because it just made it seem so ridiculous, and it really exposed how contentious it was, in addition to the extremes that people go through. She mentioned one of her clients that ended his life because of it. Like, these things happen. They genuinely do happen, because emotions get involved. So anyway, thank you guys for watching. I will be back again soon with another one. Bye.